Welcome everybody to the Texas chapter of Multifamily Masters. And so for those of you that don't know, we basically, we basically have a combined Texas virtual version of Multifamily Masters. So basically Multifamily Masters is a national brand of, local, I like to call it grassroots meetup leaders. And so Ben and I run the Houston one. Our partners in Dallas run the Dallas one. And, once COVID happened, obviously all the in-person meetups kind of got canceled. And we decided, there's a lot of online virtual meetups. Let's go do, a combined one, right, where we can do better quality content, better quality people together. And so that's MFM at a high level. If anyone's interested in starting a chapter for MFM, once we go live, let us know. That'll be, hopefully summertime. Currently about 50, 55 chapter leaders throughout the country. And so with that said, I'll go ahead and introduce myself, let Ben and kind of the other people introduce themselves, and then we'll come back and I will introduce our awesome speaker for today. Now, we have a lot of interest. I think people are very interested in the topic. And, with that said, we'll go through the topic shortly. But me, I'm Ferris, for those of you who don't know me. My background is software, came from Microsoft, had a software company, and now do real estate. I have a company called Disrupt Equity with my partner, Ben. And we basically have, properties throughout Texas and Georgia. And, we are vertically integrated, have our own management company and looking to continue that growth this next year. And, I'm the one with more hair, so I'm easy to recognize. So with that said, I'll pass it over to my less hair inclined partner, Ben.
You just couldn't get away without saying it, could you, man?
Absolutely.
All right. So for everybody that doesn't know me, Ben Suttles, I am the bald one. Some would say the smarter of the two, Disrupt Equity partners. Ferris did a pretty good job of introducing us. We got about 1,500 units. Comprised of about 7 deals here in Texas and Atlanta. We're looking to kind of continue to grow in those markets. We also like Florida as well. As he mentioned, we're vertically integrated. So we do have a property management company as well as a couple ancillary businesses, including, a financing company with Mr. Anton, who's one of our other co-hosts, as well as a commercial insurance company called Strategic Insurance Group. So, we're trying to kind of be, the one-stop shop for both syndicators as well as potential investors, right? And offer good opportunities on all sides of things. So, but this is something that we enjoy. We love networking. This is what it's all about. So we will do some networking at the end. So please don't just hop right off. We will have a breakout, and those are always probably some of the more important parts of this whole thing, right? Not to take away from our speaker, who has a lot of great content to share with us, but we also get to do some networking as well. So appreciate everybody tuning in, and I will pass it off to Mr. Neil Bertrand.
Hey everyone, Neil Bertrand here.
Hi, Amanda.
Doesn't feel like a spiel now.
Hey,
22 years.
Did I knock you?
VP
All right, go ahead. I'm muted.
VP of Asset Management, VP of Acquisitions. Actually partnered in 208 units with Ben and Ferris. Partnered in a 223 unit Class A new development in Santa Fe, New Mexico, and looking forward to a very productive 2021. Got some things in the works that I'm excited about. So,
Heck yeah.
All right. Ronnie?
Ronnie.
How's it going, everyone? Thanks for attending the Texas Multifamily Masters Meetup virtual. Name is Ronnie Phillip. I'm with the Kingley Group, a real estate private equity firm based in Dallas, Texas. We focus on large A and B multifamily across the Sun Belt region. So happy to be here. And I put my contact info in the chat for those who want to connect after.
There you go, Mr. Ronnie. Keeping it short but sweet. He's the guy with the beard, always liking the network. And Mr. Anton Matley.
Hi, everyone. As Ben mentioned, I'm from a place like this. I was born there. That's Lucerne in Switzerland. Now I have been living in the Dallas area for around 15 years. I'm a co-founder and CEO of Peak Financing. We arrange financing for commercial real estate with a strong focus on multifamily. And within that space, we have a very strong knowledge in helping syndicators getting their deals done.
Ferris talking before.
All right.
There we go. All right. Sorry about that, Anton.
Oh, no worries.
All right. Well, then that's everyone, right? All right.
I think
I
good.
think
so.
that's
Yeah,
everybody.
I'm not
Yeah, I think
sure.
fourth person, John Montero, won't be able to make it today, so that's his introduction.
He was
So,
actually working today. I mean, can you believe this guy? You know, come on. You know. So yeah.
yes. So with that said, I wanted to go ahead and kick it off, right? So, just kind of really quick, right, in terms of just the structure, right? We'll do about 30 minutes, 40 minutes of presentation Q&A, right, with our speaker, and then we'll do what we like to call kind of breakout rooms at the very end, right, where we'll break out the audience into smaller groups, right? Multifamily is all about the people, relationships and partnerships, right? And networking is a huge part of that, right? To really enable that. So, the breakouts is very valuable. You get to smaller group setting and get to know somebody new, right? Tell them what you do, where you're located, what you're looking to do. And again, that's how you find synergies, right? I met Ben at a meetup and, the proof's in the pudding. And so, really, I would love everyone to take advantage of that. But that said, right, I wanted to go ahead and introduce Brian. Brian is an attorney who we've had him speak at a different event. I thought it was awesome information. And honestly, I think it's a space that not enough people think about until it's a little bit too late. I'll let Brian kind of share more about that. But, really, he's going to talk about asset protection, right? And for those of you that don't know what that is, right, it's really about how do you structure your net worth, your investments, everything in a way to help protect you, right? I'm not the attorney, so I'm not going to say more than that because I don't want to screw it up. And Brian have to tell me everything I said wrong. So I will leave it to Brian, who, we're excited to have him on. Brian, thank you for taking the time to come out, and hopefully the audience gets a lot of value with that. So Brian, you want to go again and kick it off and kind of introduce yourself?
Yeah, thanks, Ferris, and thanks, Ben, for having me on, putting this all together. And so far, you got it right. Asset protection and business entities.
I said the easiest part, that's so I can't screw it up.
Right, you got the word. You got the word right.
He was reading it off the screen, dude. Don't give him too much credit.
If my voice gets a little hoarse, I was actually been talking all day, and so you guys are catching like the last part of this. But so a little bit about me. Asset protection attorney. I only do asset protection. I got into asset protection on the litigation side of the law and trials and just seeing what didn't work. And especially for real estate investors, like your lives, you're investing for a legacy, a long haul, to leave it to your family, your kids, your grandkids, whatever that may be. You're so focused on deals and, return on investments, metrics, building. You generally don't think about losing it until it's too late. And the real order of this should go asset protection, tax planning, then your investments, because you need to protect what you have or you're not going to have it when, all hell breaks loose. And so a little bit more about like me and why you care about what I have to say is like, I was selected to Best Attorneys of America 2020, Super Lawyers Rising Star 2015, Lawyers of Distinction the last 3 years in a row, top 100 person in real estate, top 100 high stake trial attorneys. So a lot of cool accolades because I just work hard and I'm very passionate about what I do: law, money, finance, and investing. As an investor myself, I just don't like to lose things. And so I do normally have a slide presentation, but this is kind of more loose and I want to keep this more as just a conversational piece in education, not bore you with a bunch of slides. So if Ferris or Ben have some questions to kind of pause and like interject, or if they can follow along in the chat and, bring in a question here and there, I'll try to get to as many as I can while I talk. Does that sound good, guys?
Absolutely, man.
Cool. And so like, I just like to start off with the premise of, like the legal system isn't what it used to be, like it's broken. And that's what we're trying to fix and level is the playing field. I call it a sue happy nirvana. There's more than 40 million lawsuits filed every year. Something like 99% of all the lawsuits are filed here in the US. It's become a multi-$100 million, billion-dollar industry. And so what asset protection really is, it's not traditional estate planning. It's just modern estate planning. And what we're doing is just placing a legal barrier between your assets and your potential creditor, before it's needed. It's really that simple, like a barrier, like a safe that you're going to put your gold, your guns in, your valuables, anything of value you want to put behind that legal barrier and out of your personal name so that it's not easily attached with a lien or a creditor or somebody trying to attack you. And so like collectively now we're protecting up to over 5 billion worth of assets already. And things that you did in the past, like revocable living trusts or having everything in your own personal name, it just doesn't work anymore. Revocable living trusts don't protect you. They're not designed to. They only go into effect when you die. They're only there to protect you from probate, so it's easily passed through and skip the courts, death taxes, and your death benefits. And that's really what it is. There's nothing there to protect you from creditors while you're alive. And so that's kind of what we need to go over is what are the rules of the road? And like, what's the roadmap? And I like to start at the foundation level and build up. So I want to start at LLCs, limited liability companies at the foundation, build up to a mid-grade level protection when you turn about 500,000 net value, and then bring it to more of the big guns, asset protection trust when you hit about that 1 million net worth mark, so that you see wherever you are on the sliding scale, that works, the pros and cons, and you kind of can figure out and gauge where you are and where you need to be. And so I'm just going to jump in and start going over these key concepts. And
can I stop you there, Brian, real quick? So a lot of people, and I don't mean to break up your flow, but I know a lot of people, obviously it's a multifamily kind of centric, bunch of folks that are interested in that. A lot of the lawyers that are kind of in the SEC space have kind of said, you buy this through an LLC. This adds some level of protection.
Yeah.
Then there's the other bunch that say, oh, you also need a manager LLC. Can you kind of talk through the structures and really, is there any real asset protection there for the managers as well as maybe even the investors?
That's exactly where I'm going to go to right now with the LLCs. And I'm actually going to spend the majority of my time blowing up the LLC, just because there's so many misconceptions about it and in trial and what state to go and pick them in and how to do it and why. And you fall into a lot of traps of law firm advertisers and marketers. And
Brian, it's limited liability. No.
Right. Limited liability company.
That's what it's for. But no, and
that's exactly where you're jumping my saying, man. Come on.
I know. But I just wanted to add, if anyone has questions, go ahead and write them up, and then Ben and I will kind of moderate those just to help
and
avoid people randomizing.
And Ferris hit it right on the head. Like, they don't hide the limited part of limited liability company, but a lot of this is sold as a silver bullet. And so I just want you to remember, like, the people who wrote the statutes told you straight out is limited. So let's just start with there. It's not a silver bullet. I like LLCs. I use LLCs, but it's an entry-level place of protection. And I'm just going to start breaking down the LLC. Like I said, think of winter, like it's cold, it snows. I'm from Lake Tahoe. I'm from Michigan, as well. We get a lot of snow. We dress in layers. And so that base layer is going to be an LLC. And then you're going to have a mid layer. That's going to be, like it's made out of, merino wool or something like that, a little bit thicker. That's going to be over your base layer. That's going to be a limited partnership. And then your outer coat, the weather's really bad outside, or we're going out to Alaska or something, that's going to be an outer shell waterproof layer. That's going to be an asset protection trust. And how we structure these all together is how an asset protection plan really comes together. You want it to be flexible because, like, when you're skiing or something and you get hot, you want to be able to take layers off. You want to be able to adjust as the temperature of your life adjusts. And so, like I said, and like Ben was jumping at, LLCs, lots and lots of misconceptions and unspoken problems with them. And so this is where I'm going to be spending most of my time talking about, because we all know what an LLC is, limited liability company. There's some limited personal liability between you and your assets. But what's not talked about, and some of the problems that I generally see are, like, let's say clients with 15 different properties. And so they have, 8 or 9 different LLCs, and they're all single member LLCs, but they're all in a client's personal name. So your name as the manager. The problem here is that courts now are having a tendency just to completely disregard single member LLCs. And so because of this, they're just basically worthless. What you actually want is a single member LLC that's going to be holding your real estate to then be held and owned by your second layer of protection, which is going to be a multi-member limited partnership, not you. And so by doing this, what you're now doing is properly layering your protection. Your mid layer will be owning all of your LLCs that are owning all of your real estate, that base layer protection. And then all those individual K1s just flow directly through to the management company. So you'll just have one tax filing. And what you also did now by, adding a mid layer is simplify and clean up your planning from a tax perspective and accounting perspective. But like Ben was hitting up on, a big issue, charging orders. Where do we set these things up in? Like, that's what you're doing when you're shopping around in different states. Well, Delaware, Wyoming, Texas, Nevada. Where do I go to set these up on, and where do I even care? And so you hear about these states and that they're really good about protecting their LLC members. And some of these states have privacy or anonymity, which I'm going to blow up in a little bit, because I know Ben's going to jump the gun on asking me that in a minute.
I'd never do that.
And they're like, oh, it's better to do that. So I'm going to go do that. And it really just depends on what you're holding and where you're holding it. So, and I'm going to pick a lot on California here, just because California is a big state. Lots of people live in California, and most California investors are investing all over, the nation. So California is a great example, but the principles apply to every state. All right. So let's say, for example, it's California real estate. You're a California resident and you're investing in, an asset that's out of California. And you set up a Wyoming LLC because somebody on the internet or your CPA told you it's better, or even worse, they ask you to create an S corp to hold real estate in. And then you go and you hold a key piece of, real estate in it, and you're paying California franchise tax on this out-of-state Wyoming LLC. What you've just done is called converting your Wyoming LLC to a California LLC, because you're doing business in the state of California now. You're paying franchise tax in California. You're a resident of California, and the judge, if you're getting sued from that piece of property, yourself in California, or if it's a California asset that you put into a Wyoming LLC, now you availed yourself. So a judge in California or any other state doesn't care that your LLC is a Wyoming registered LLC or a Delaware, registered LLC. All they care about is doing business in the state of California. It's availed itself of that protection and the laws of California. That's the state, if that's where the asset is in, where the LLC needs to be created in. Or if it's a Florida asset, you need to create a Florida LLC, because those are the states the injury and the lawsuits are going to be coming through. Those are the states that have jurisdiction. You can't just up and take protection laws of another state where there's no nexus. It's called a legal nexus with you to another state. You don't just transfer state laws like that. And especially with real estate, specifically with real estate, because real estate is put into a limited liability company as a holding company. That's it. You don't operate out of it. And so when you're being sued through that asset, all the lawsuits come through that state where the injury occurred at. And I want to harp on this just a minute longer, because I get a lot of calls on this from clients that are just confused as heck on this stuff. And why not just put everything into a Wyoming LLC? And again, it's because just by simply owning an out-of-state LLC, you have to register that LLC as doing business in the state that you're a resident of. So I'm just going to stick with California. Now that LLC is registered and paying franchise tax in California, you just gave California jurisdiction over that LLC, and you're a resident of California. And you have, let's say, a California asset that's in an out-of-state Wyoming LLC with no connection to Wyoming whatsoever. You just did this fancy legal term called availing yourself and your Wyoming LLC to the state of California, and have what's called a direct, substantial, systemic contact with California. It's just a fancy word of saying California has a jurisdiction. We don't care that you're in Wyoming. So I hope that point, makes sense. And especially comes down to, once your veil is pierced, that's where they're going to get access to all of your assets. And piercing a veil in real estate for LLCs is very easy, because the nature of an LLC for real estate is just to hold that real estate. So the main argument you make when you pierce a corporate veil is that LLC is an extension of yourself, because it doesn't do business. It's just holding real estate that you own. And that's the first go-to argument when you're piercing a veil. Then it goes to accounting issues and commingling fund issues. And those are generally three arguments that win 9 times out of 10. So our principle when it comes to LLCs is very simple. Just keep it simple. Whatever state the asset's in, that's the state the LLC is created in. And so as we're going through this, analogy of LLCs, we get to the really next big, massive misconception of anonymity. Like a really big fancy word, like you think you're going to just become a ghost and disappear, and no one's ever going to find you to sue you, and you can just ignore lawsuits. And this is just completely false. But I actually get these questions a lot and almost every day. And so when your LLC is sued, you're going to be legally required to appear and defend it. And then you're going to have to actually start making declarations of assets that you own legally through the discovery process once that begins. So at that point, anonymity is out the window. Like when you create a Wyoming or Delaware LLC, you have to create a person registered of service. That means that person's sole obligation is, when you get sued, to give you the service and say, congratulations, you're being sued. Go defend yourself. So there's no more anonymity. So you have two options at this point. You either lie under oath and say you own nothing and commit perjury, which then means you go to jail and have civil contempt lawsuit with you as well, or you just disclose your assets. And where I'm not an advocate for committing perjury or lying. So that's where people need to understand anonymity exists and is good before you're being sued so that people can't find out who owns something and then go stalk you at your house. That's what anonymity is used for, not for you to disappear and avoid lawsuits. So you just need to understand the purpose and place for that. And the last big misconception, and because it's a hot topic, is series LLCs. Series LLCs is where you can create a parent umbrella LLC and then have a bunch of sub-children LLCs underneath it. And you put property A in child series A, property B in child series B, C, D, all the way down. The issue is not every state recognizes series LLCs. Like, for example, all the coast. California doesn't recognize series LLC. So if you're a resident of a state that doesn't recognize or have series LLC statutes, or your asset is in a state that does not recognize a series LLC, you just created something completely worthless that's not going to do what the value is that you intended, because the states don't recognize them. They're just going to recognize it as one big massive LLC. So the only time I would recommend considering a series LLC is if you live in the state that has series LLC recognition statutes and the asset itself that you want to protect is also in a series LLC state. Otherwise, it's not going to do its function, and you just created a false sense of security. And so after I blew up, a bunch of, LLC myths, like I do use them, just realize they're the foundational level. That's the building piece. All those LLCs need to then go and be held and owned into the next stacking, a limited partnership. Most people stack up to another LLC, and that's the wrong stack. You want to be putting them into a limited partnership because of the classification of limited partnerships. They have dual classifications of ownership. So just think of it as like a split personality or dual passports. You have the general partnership share, which is the management share, and then the minority share, which is the ownership share. All those LLCs will be owned by the GP portion of it. And you want that because then you're going to be the managing member. The reason this is important to have it as a limited partnership is because we can then add the third layer when you get to about $1 million net, which is an asset protection trust, which would own that limited partnership. But you have to have the dual classification split ownership. You don't get that with LLCs.
So real quick, Brian. So,
Yeah.
so just we'll use us for example. I'll be the guinea pig on this, right? We got 7 different deals, multiple other businesses, right? Would you suggest that all the properties are owned in LLCs?
Mm-hmm.
So you're saying that have that LP portion own the 7 LLCs, right?
Correct.
And then say me and Ferris, obviously we're the co-owners of Disrupt Equity. We would be the GP of the limited partnership.
It could work like that. For you guys, you would want to create your own separate individual protection systems off of that, and protect your own individual shares from each other as well as other people. But yeah, so your membership shares of those LLCs would be owned by the a limited partnership.
Gotcha.
Right. Gotcha. You're not putting your name as the member manager of an LLC. It should be the limited partnership. And then you're just a managing member of that limited partnership.
So getting away from that single member, the single member is now the LP.
Correct.
Right?
Correct.
Okay.
And now you're stacking up properly. And the reason you want the limited partnership is it gives you somewhere to go for the next third layer. When you actually get to where you want to be, everyone's goal when you're investing in real estate is to be wealthy. Like you're trying to get there, whether you do or not. Like that's just, it depends on how great you are. But you at least need to know the roadmap to where the stop is. And that would be eventually you're successful. You have $1 million net worth, which means minus liabilities. So now you have a lot of units. You have a big target on you. That's where we come in with asset protection trust. And I'm going to break down asset protection trust by breaking it down through jurisdiction. And so this is your third layer, your frozen tundra layer, or you're walking around in Siberia and you're trying to stay warm and comfortable. Picking the proper jurisdiction is the big guns. And what jurisdiction in this means and why it's so important is that the laws and the rules that govern you and trusts and business entities are going to be different from one jurisdiction to another, one country to another, one state to another, even one country to another. And so you have 2 options when you create asset protection trust. You can either create them domestically in the US, or you can create them offshore in another country like the Cook Islands. So just for a little bit of historical context on this, the offshore trust came first in 1984. In the famous Cook Islands, they created what's called an asset protection trust. I personally just prefer, because I have generally higher net worth clients, I prefer the power of just going offshore when I need to, because it's just the best home court advantage. And the power of the foreign offshore trust is it's just what's called statutory non-recognition. It's just the golden standard for the last 40 years. What this fancy word means is that a US judgment is just completely worthless in the Cook Islands. You would have to start a case all over from scratch. They're going to be facing the highest legal standard in the world, the murder standard, which is beyond a reasonable doubt. The plaintiff, so the person suing you from, are going to have to front all the court costs plus flying the judge from New Zealand. You can't take your US attorneys with you. They don't allow contingency fee attorneys there as well. And if you lose, you pay, which we don't have that system here in the US. So it's very hard to be preyed upon because of that. And there's only a 1-year statute of limitations there. So by the time the person suing you realizes like, oh shoot, I have to sue them in the Cook Islands, the ball's already gone by them. They didn't realize they had a swing. But here's the negative of it. If you're purely foreign, it's a hard pill to swallow. It's an overkill for most people. And honestly, most clients, because of that, generally go domestic. But the problem with domestic, they came about 10 years later, of all places, Alaska. And then, like once one state starts, you're going to have Delaware, Wyoming, Nevada, and then 20 other states, followed suit. The issue is not all states have asset protection trust legislation like California. There's actually a famous case in California, Kilker versus Steelman, 2012, approved by the appeals court that says, if you're a California resident, we don't recognize other states' asset protection trust. So if you go to Nevada and get an out-of-state Nevada asset protection trust, too bad, we're going to pierce it. So that's where, as a California resident, you actually have to, if you want strong asset protection, consider the combination of a bridge trust, which is the combination of both. I prefer a bridge trust because a foreign asset protection trust, it's expensive. You're generally talking about like $50,000 to set up a foreign asset protection trust. You have a lot of IRS compliance and disclosures. They cost about $10,000 a year to maintain. So unless you're, really successful with a lot of high liability, or you're just under fire and being in a massive lawsuit, I don't recommend going offshore. I recommend a combination or a hybrid of the both. It's just a combining the best of both worlds. And what you're doing is having the offshore protection, and then you build the bridge back by maintaining IRS domestic compliance. And so the IRS classifies your trust now as a domestic trust, which means it's cheaper to start, generally around $30,000. And then it's cheaper to maintain, generally around $2,000. And you don't have any of those IRS disclosures or any disclosures at all because it's a domestic trust. So you get the best of both worlds. If you are sued, you drop domestic compliance. Now you're purely foreign. Now you have statutory non-recognition, the big guns to level the playing field. And until you need those big guns, like a contractor, you just want to keep it nice and safe in your back pocket. And so I know we went over a lot, and in a short amount of time. And so how it all kind of works and should come together as just a reminder is like this. The first layer is your base layer, your insurance and your single member disregarded LLC. And these LLCs are going to hold your real estate and other assets that can hurt somebody, or that can have, has a key to it that you need insurance for, that can go boom, like boats and planes, real estate investments. The next layer up is your multi-member asset management limited partnership, which is going to act as your holding company. And it holds the bulk of your assets like those LLCs, or cash, stocks, bonds, passive syndication shares. So if you're investing in syndications passively, you put those syndication shares directly into the management company, receivables, whatever. The final layer is going to be your outer layer, which is that asset protection bridge trust. And it's going to be the minority limited partner of that mid layer, that limited partnership. And that's going to be the controlling interest, like the ownership interest. But, and that separates out ownership from use and enjoyment. You're going to be the trustee, the creator, the beneficiary of the trust. You're going to be the manager of your management company. And then either two things happen: you die and your assets get distributed per your living trust directives, or there's a crisis like a lawsuit and the bridge trust is triggered and the assets cross the bridge through the migration policy to the power of the statutory non-recognition. And then having that power in your back pocket gives you the leverage to settle cases generally for pennies on the dollar, if not just chase them away.
Brian, we got a couple questions kind of coming in.
Yeah.
We do have a fair amount of people that have just invested in real estate versus, we're kind of managers of real estate and syndicators. A lot of people are just passive. Talk about what layer of protection they really need. One gentleman, asked, for example, does my LP share need to be held in my own LLC instead of my own name? I guess they're looking for what layer of protection do they need as passive investors?
This is a great question. When you're just starting out, LLC, and it'll be in a single, most of them, my clients come in, with LLCs as a single member in their name. We can then adjust those, take them out of your name as you grow, and then take those LLCs and turn them into, members of the limited partner, having the limited partnership, own them as the member. So just start out, have the LLC single member in your name. If you're just passively investing, it depends on what the rest of your assets would be like. I would say probably recommend having the limited partnership and putting them into there, because then that limited partnership will give you more flexibility to whatever other assets that you want to have later on down the line. Maybe you will start wanting to own real estate. So then you need that LLC. So you have the right, you need to start with a midsection and then add the LLC foundational layers depending on the assets you own later on.
So it's kind of, what is your goal, right? What are you trying to do over the next few years?
Exactly. And, and one thing I want to jump on is, like I mentioned, like the wrong thing for CPAs to be doing. I get why CPAs do this and they're not doing it wrong. Just a person talking to their CPA needs to understand when you go and you're investing in real estate and you're starting out, their job is just to maximize your tax filings, mitigate your taxes. They're not thinking about what happens in a lawsuit. That's what lawyers do. So I get a lot of clients, some of them with like $2,500 million real estate portfolio, all stuffed into an S Corp. The problem is I can't really protect that because S Corps have shares. Even if I take it offshore, it still ties up, the assets because it's in the S Corp, and I can't exit the S Corp with all those assets because of the back taxes that that they would end up having to pay because of the S Corp status. So now they're financially tied to that S Corp with assets that are risky that they can't exit out and I can't really protect. So when it's real estate, you need to realize what's more important for you, taxes or protection. I would lean on the side personally of protection because you can always then mitigate your taxes by working with great CPAs and great wealth managers, and deferred appreciation and all of those tools that they can use. Get the protection system locked in properly and then mitigate your taxes the way it should be. Don't weaken your system by, starting out with an S Corp because you're trying to, maximize taxes. You're going to outgrow it and then trap yourself.
So maybe just to kind of recap that for everyone, I think that's actually probably a pretty big point. It's, think about the layers and progress up, right? I think if I'm hearing you right, it's start off with an LLC. So if I'm a passive LP investor in a deal, I create my Fairless Investments LLC. I invest in deal 1, invest in deal 2, invest in deal 3. At some point, I grow past that. Then we talk about basically setting up a new entity that basically the LP portion of that entity owns. We transfer all of those shares into that entity, and then continuing from there, right? And I think maybe the other really important point is think about this early on, not necessarily go out and spend all the money to do this right until you're ready, but more so not getting in a bind where if you're doing that transfer thing, it's not just a piece of paper. Now there's taxes or some other issues that you have to pay, right? Because now you're really selling it to another entity versus just a transfer. Correct. I think you got to know where you are in the sliding scale and where you're starting out at, but you also have to know where you want to grow to and what your plan is. So it's like creating any business. You have to understand asset protection, whatever bucket you're falling into, you're going to have to pay for, you should set that up because the last thing you want to do is like, you don't have anything to give if you don't have it. So you got to protect it. And then work with your CPAs. So start off where you're at, like I always tell people, like, don't pay for the Taj Mahal if you're, starting out, or if you're shopping for a Ford, you're not going to pay for a Ferrari, like work within your budget. Once you have, I would say 4-8 units and 3 or 4 LLCs, that management company comes into play because now you're going to save money on your tax filings because it's just one tax filing going in, 1K1 in the management company. So you're actually going to be saving your money in the long run now
from a tax standpoint. So that's where you need to realize, okay, I have to maintain these 3 or 4 LLCs now. I need to add that management company because it's starting to get expensive filing 4 different K1s, $1,000 a pop, plus my personal tax filings, $5,000 when I really only need to be filing 1 K1.
Got it. And just really quick for everyone listening, right? This is getting recorded. We will have a recording. And there's probably a lot of turns. People probably going to want to watch it multiple times. So just know that we will have that. All right, let's continue on then. I mean, did you have more?
There's a couple more questions. Don't want to break your flow up too much though, Brian. If you still have a few more things, we can maybe move through that and then we can come back to the Q&A if you'd like.
Yeah, I mean, I can just, like one of the big misconceptions I get is on insurance. I get some people like, oh, I have insurance. That should be good enough. And I'm a big guy. You got to have insurance. Like insurance isn't the end. It has a lot of shortcomings. I see a lot of clients having this false sense of security, thinking like, oh, I'm going to get sued. I'm just going to solely rely on this. That's what it's there for. That's just not the case. But again, like I do recommend you have as much as you can cover, that you can afford and you want. But read your insurance policy, read the fine print, understand what's not covered and what the claim limit is. Most people, if I go in, like I'm talking at a global summit, and I ask people like, raise your hand if you read the fine print of your insurance coverage. Like, I don't think I've ever seen a person raise their hand. Like, who knows what a claim limit is? Like maybe 4 or 5 people. What is it? Like I don't know. But those are very important things when it comes to litigation and trial work and what's going to happen. And so a good place to start is, it's just a matter of, it's not a matter of what, but when you're going to get sued with real estate, because it's the most heavily litigated area of law that there is. And there's just so many areas where something can go wrong. It's not because you're being a bad, landlord or anything. It's just because of the nature of owning real estate or forming deals, they fall apart. And so just keep in mind that insurance companies don't cover you for fraud, punitive damages, or intentional wrongdoings. And they don't pay claims that are, the direct result of unlawful acts. And what you guys, and girl, everyone listening really need to understand is just the basic concepts of insurance law. And this is where the law in litigation, why there's insurance defense, attorneys. From the very first statement or communication or an email that you make to a buyer or a seller, or a vendor at any point, those lawsuits are going to be based on allegations of fraud. And they'll always be added in the lawsuit, and the courts are going to be looking at those statements. For example, you sending in an email like the plumbing's done, and the court is going to say, all right, those are statements. And so statements are intentional acts because I intended to type on my keyboard. I intended to pick my pencil up. That is an intent. It's not meaning you intended to defraud somebody. It's just what in the legal sense an intentional act means. And so where this leads with your insurance company is your insurance is going to say like, oh, okay, well, that judge just declared this as a potential fraud or wrongdoing, an intentional act, and we don't cover for potential wrongdoings or potential intentional acts. And so we're not going to cover you. If you think we're wrong, go ahead and sue us. And so now you're being sued while you now have to sue your insurance provider. And that's not a place that you want to be in. So that's where having an asset protection system in place comes in to just hedge your bet.
Interesting. Yeah. I mean, you don't think of it through the lens of insurance. And yeah, I mean, that is a big misconception where people think that, oh, well, if I'm insured, then I'm good, right? For that slip and fall or whatever it might be. It's
great for slip and falls, but it's not, like big ones, mold. I mean, like I've had to argue, in litigation, like $5 million, $40 million, litigation claims. Like some of these were like apartment, buildings and stuff like that. But I mean, that's going to clean you out if you lose or you don't have, a protection system in place to, help protect you. And that's where that comes in. But little things like that, mold issues or fire, your negligence of your own life, driving your car, giving the keys to your neighbor and something happening, business adventures with somebody else not related to real estate. It's the whole scope of your life that you need to protect yourself from.
Yep. So Brian, absolutely. I take it you don't let a friend borrow your car?
I'm not going to take it that far, but that's not my legal advice. That's not my legal advice, but
we won't pin you in a corner on that one. It's all good, man. Well, we got some questions, man. I don't know. You open to it?
Let's rapid fire and see where we end up.
Yeah. So, okay. So
if people have questions for Brian as well, I mean, he included his contact information. We'll have him included again at the end, and we'll also send it out with the recording. please,
Yeah.
reach out to Brian and kind of if you do want to get a little bit more in depth. But if people have questions, go ahead and ask them. So Ben, you want to roll with what you were going to say?
Yeah, I'll roll with a couple that I got here. So, does it help to set up additional LLCs for each partner of the primary LLC? I don't know, Don. I don't know if I understand that. Maybe Brian, if you understand.
So like you're syndicating a deal? Is that the plan? Is that like?
I'm assuming that's, yeah. I mean, most people are going to be asking questions through the lens of syndication.
Yeah. So if you're the GP and you're syndicating it, then go through the LLC. Yeah, and then you would have their shares going over to the limited partner. They can protect theirs into their own protection trusts, and then you should have your deal and your LLC protected up into like the management company. You can do that. Yeah.
And let's answer this one a different way because I actually interpret it differently. So let's say it's a JV. 5 people doing a deal together. They create JV LLC.
Mm-hmm.
I think what he's asking is, does it make sense for, if it's me, you, and Ben, right?
Oh,
create for me, you create LLC for you, and Ben creates one for him.
Gotcha. Yeah, I would still put your shares of the LLC into your management company. Absolutely.
Okay. All right. So this one says, if I already invested in syndication, is it easy to transfer my ownership shares into a new LLC? And does my LLC need to be accredited? I know this gentleman, so I know he's talking about another thing where, obviously 506B, 506C, having to be accredited to invest in some of these.
Yes.
I know that's not really asset protection maybe, but do you know the answers to those?
Yeah.
as
So
well?
that's not being accredited, that has nothing to do with asset protection, but I would say in the sense of transferring assets, that's a good question. Even the assets in your own personal name, like we have over 3,000 clients, over $5 billion worth of real estate, for the last 30 years with my partner included. We just transfer the assets straight from your name right into an LLC. Unless you're not paying that mortgage, we've never seen a bank call a note due because of that. So we don't use land trusts. If someone's starting out, we just put the asset straight out of your personal name straight in the LLC.
All right. So, because that's our next question. So hold on. So how does land trusts help in shielding an owner when the beneficial interest is the LLC? Also, in what state should the LP be held? So it sounds like two different types.
Yeah. So I'll give you a twofer. I'll go with Arizona for the limited partnership,
Okay.
specifically because Arizona is the only state that has this code. So it's section 29-333. And it's a very special code because it allows you to do what's called a unilateral withdrawal and disconnect the limited partnership from the trust. So in a state of duress, like a lawsuit, I can now statutorily disconnect the limited partnership from the trust statutorily. And that's the only state that allows you to do that. So that's why we like Arizona for that. And then I forgot what the first part of the question.
It was how does land trust help in shielding an owner when the beneficial interest is the LLC?
Doesn't. A land trust has zero protection. It's just a trust to hold something. So its protection has to come through something else like an LLC.
That's the obfuscation piece, right? There's obfuscation, which is different than protection.
Yeah.
Okay, so that doesn't shield at all then, right?
A land trust is literally just a trust that you put land in to hold. It has no protection on its own whatsoever. It just allows you through the St. Germain's Act, because it's a trust, to transfer an asset into the trust without the fear of a bank calling your note due. But if you just look at historical trends for the last 40 years, I've never seen, and I can call up, hundreds of firms that do this at the same level, like high, billions of dollars. We've never seen a bank call a note due, simply because
they don't care, man.
And as long as you're
paying your note, that's all.
Well, they'll call it if you're not paying your note. If they're not paying your mortgage, man, like they'll call it. Don't get me wrong. It's if you're paying your mortgage, they don't rock the boat.
Yeah. Why would they, right? All right.
So I saw one like Hong Kong. I saw one here. Like, we don't mess around with what Cook Islands is the best. That's why we use the Cook Islands. Yeah.
And there's one more question I think we skipped over. It's if you have over $1 million invested in 10 plus deals as an LP, would you still create all of these layers?
If they had $10 million,
if you had over $1 million invested in 10 plus deals as an LP, would you still create all these layers?
I would. It depends on what the rest of the asset, your liability from are you a doctor? Maybe, I don't know, with different, liability in your life. That's where we have to look at the whole scope of where you're coming from, not just what you own, because different people have different liability. I would definitely at least put it into the management portion of it to protect a layer of it from your own negligence or the negligence of the general managers or somebody else tying up your land and your interest shares, then we can talk about where the rest of the liability from your life comes from, to where maybe you do need an asset protection trust, maybe not a bridge trust, maybe you need a quantum living trust, which is like the little sister of a bridge trust.
Okay. All right. So I got one more here. As an LP investor, can all deals I invest in go into one LLC, or do I need to have an LLC per deal? So once again, preface it, a lot of folks on here are probably going to be looking at it through the lens of they're just investing, right? They are not indicators. And so, I think a lot of people are just looking for some guidance on that side.
You can put your limited, passive syndication shares into an LLC. I would probably say put them into a management company, a limited partnership, just because as you grow, now I won't have to transfer all of those out into a limited partnership. LLCs you just want to use for risky assets. Passive shares, they're not risky. So I would just put it into the management company. And then if you start investing in real estate or hard land yourself or something that, can add some liability to yourself, then that's when you come in with the LLC at the base layer and then have it owned by the limited partnership.
Cool. So just to recap, just so I understand, because, on this stuff, this is interesting, especially as you kind of grow in this space, you really need to be thinking about this. I mean, lawsuits are thrown around all over the place. Yeah. So if you're a syndicator, you're a sponsor, you're saying LLC to LP to, to the
asset protection trust.
Yeah. To the asset protection trust. Right.
Yeah.
And then if you're just purely doing passive investments, maybe just start off with that LP, throw everything into that. Right.
Correct. And the great thing, don't put your personal residence into an LLC though. That goes directly into an asset protection trust, because then you'll lose that $250,000 tax credit if you were to sell it. And then the only way to get it back is you'd have to transfer it out of your name and have it in your personal name for 5 years. So the way you protect your personal residence is it has to go into an asset protection trust.
Okay.
That's maybe a good segue to the next question, which is, we'd really like to know when will we get the recording of the session? I'm hearing a lot of things that I know are important, but I'm not sure if I'm able to capture all of that. Yeah, we will send out an email to everybody that's in here with the report.
Yeah, next few days.
Probably, what's that, Ben?
I said probably in the next few days.
It'll be the next few days, probably Friday, but we'll see.
And we'll include, once again, everybody, we'll include Brian's contact info too, and
I have on my site tons of educational videos and frequently asked questions and legal. I have my website more as just like a legal resource for people to go in, lots of case law, even just to break things down so people can just get good access to information. www.btblegal.com.
Okay.
Yeah, it's B like boy, T like Tom, B boy, legal.com.
Correct.
All right. One last thing here, Brian. I'm not sure if you're going to be able to. So if you have assets in an LLC, would there be a tax consequence to have the LP become the owner of the LLC? I don't know if that goes into the CPA world or not.
Yeah, I would just go like kick that over to your CPA. But all you're doing is transferring the ownership, membership name. You're still going to have to file your taxes of whatever income came in from that LLC at that time. And then the rest of it will just kick over, afterwards into the LP.
Well, I got a question. Actually, while I have one more to this, kind of, it's just relevant. I guess that's what made me think of it is, what's the right way to work with basically an asset protection attorney and a CPA, right? Is it to get you guys both on this call and just kind of do the super structuring with just to
yeah, it's a great question. It is a what's the word I'm looking for? I can't think of the word right now.
Balancing act, really, right?
It's a symbiotic relationship.
Symbiotic relationship that we have to have. That's exactly. I was like, I don't think that's the right word though. But it's a symbiotic relationship that we have to have. But you have to add another wheel to the clog to do it right. The wealth manager, because the wealth managers are going to know more about like how to maximize, and they like audit your CPA and then tell the CPA like, hey, here's an extra form that we want you to file for this. They really get deep into the tax mitigation strategies. The protection guys, we just need to know what you own so that we can create the buckets around it. And then whatever your wealth managers are going to do investment wise also, so that we can protect it. And then your CPA needs to know what's being created and if it's passive or not, so that they know what tax filings to file, because your CPAs file the taxes, your wealth managers maximizing the mitigation of your taxes, your attorney builds the structure that protects it. So we all are just kind of in, talk to each other. We don't have to always be talking to each other, but before a deal and after a deal, we need to know what's going on.
It's like a house. You hope the electrician and the plumber
Yeah.
and everybody kind of did their parts and the thing works in the end, right? So
Absolutely.
So,
We
Brian,
appreciate it, Brian. Yeah.
Yeah, man. Thanks for having me on. I know that I went over a lot of information, and so, I tend to blow up a lot of misconceptions, and there's a lot for people to digest, and that's what the whole point of it is.
yeah, absolutely. If you could please kind of, just post your information one more time for anyone that didn't see it, your email.
Yeah, I just went
website.
on to everyone and just put the website there. Here's my email.
And before everybody jumps off, right? Because if you guys aren't going to join us for the networking, you can click those 3 little dots right there, and you'll be able to copy and paste what's in the chat. So, pro tip that we got a few months ago that I always like to remind people of, so you can capture everybody's
Easy there,
contact
Jeff.
info.
Easy there, Jeff. From our friend Jeff, that's good. But no, Brian, appreciate it. Thank you very
Yeah, man.
much. Super knowledgeable for me. I figured, us hosting this and having you on would force Ben to finally kind of go watch this. I've been telling him we need to get, start to put a plan in place here.
Yeah,
So that
let me know next time if you want. Now you saw the slide and now you saw it without the slide.
they're different presentations.
They're
so,
different. Yeah, I think
Well,
the slides are boring, but it's easy to follow with your eyes.
I might have the team link out to both because we have the recording of the other one too, right? We'll link out both of them and people can watch the one they want, right? Two different
Yeah, I
sessions.
think the last time the problem with the slide, they didn't record to like halfway through.
Yeah, so
We got people saying they love the slides. So, I think everybody would like a little bit of that
Okay,
too, right?
Cool. Yeah.
Hey, Brian, I was just going to ask just my own personal curiosity. As I mentioned at the beginning, we're trying to spin up some in-person events. Love to see if we can get you out here too, man.
Yeah,
at some point in the future, whether it be one of our conferences or another event. I think a lot of people could learn a lot from you.
Yeah, no, for
knowledge.
sure. I love that. It's for me, it's just educating people. Like, even if you're not going to be my client, it's more about this is what it's about. This is how messed up the legal system is. Here's how you protect yourself as a trial lawyer. Here's what we see working. Now let's just work with what works at the level that you're at, and then hope we can scale you to success.
Absolutely.
Love it.
Appreciate it, Brian. And you're welcome to stick around for the breakouts if you want to, or I know it's late as well, so you're welcome to hop off, but wealth of information.
Thanks, man.
What's that?
I said, I'll stay on for a little bit.
All right. So then I guess that's a good segue. So for those of you that have been here before, right, we do breakouts at the end. Basically, we'll break out the audience into groups of about 7 people, right? And the idea is just to network, get to know somebody, right? You never know who you might meet at these things, whether virtual or in person. Talk to the people in your group, tell them what you do, what you're looking for, where you're from. And, maybe if you guys need a conversation topic, tell them about your favorite dish and what you had for lunch today, right? There you go. But fine, kind of get to talk to people. And, that's a really, really valuable part of this, right? People have created partnerships and business opportunities from it. And so we'll break the audience down into groups of about 7, right? And we'll leave that for about, 10 to 12 minutes, right? 10 to 15 minutes, depending on how flip a coin. And then we'll basically.
15.
What's that?
Do 15.
All right, we'll do 15 minutes, right? Then we'll bring everybody back to here. We'll do our kind of our goodbyes, and we'll break it out one more time, and then I'm just going to leave it open at the end, right? So definitely stick around, guys, and look forward to seeing you guys in the breakouts. So I'm going to go ahead and get this kicked off here.